Well, it's another week and another markup of an immigration bill that takes an already deportable crime out of the headlines and then makes it a deportable crime again, but this time without requiring any conviction. So the bill is characteristic of what's going on. It makes the commission of a variety of fraud offenses a deportable offense without requiring an actual conviction of fraud. But conviction of a fraud offense is already a deportable offense. It's considered a crime involving moral turpitude and a specifically enumerated aggravated felony, the conviction of either of which subjects an immigrant to deportation. In the past, we've heard our colleagues claim these bills are necessary to resolve ambiguity, but where's the ambiguity? Section 101.843 of the INA lists fraud as an aggravated felony and therefore a deportable offense. Even more starkly, we've got long-standing Supreme Court precedent from over 70 years that makes it clear that fraud is a crime involving moral turpitude and therefore a deportable offense. In Jordan versus DeGeorge, a Supreme Court case decided in 1951, the court held that the phrase crime involving moral turpitude has without exception been construed to embrace fraudulent conduct. The opinion stated that in every deportation case where fraud has been proved, courts have held that the crime in issue involves moral turpitude. The court even addressed the idea of statutory ambiguity, declaring Congress sufficiently forewarned respondent that the statutory consequence of twice conspiring to defraud the U.S. is going to be deportation. So the law is settled and it's clear. The initial version of this bill, in fact, even required a conviction. It's the amendment in the nature of a substitute that the majority will offer, which strips that requirement away. And probably this is simply to create some novelty in the legislation to justify it. Otherwise, it's completely unnecessary. It's redundant. What's wrong with the state of the current law? It's not impossible to convict people of fraud. People are convicted of fraud all of the time. Even President Trump was convicted of fraud by a jury of his peers of 34 counts of falsifying business records with the intent to defraud. And even with trial, due process, the presumption of innocence, and jury conviction, Trump does not think it was fair. How can it be fair to dispense with the requirement of due process in a trial, presumption of innocence, and a jury verdict entirely? One might say the rejection of the conviction requirement reflects the administration's determination to focus on fighting fraud today. In fact, due to the Trump administration's single-minded focus on immigration, the FBI directed its agents to deprioritize white-collar crime and to devote their time to immigration instead. As a result, the prosecution of white-collar crimes, which includes a whole variety of fraud offenses, of course, was down more than 10% last year compared to white-collar prosecutions in the last year of the Biden administration. The bill also makes offenses related to theft or bribery and programs receiving federal funds a deportable offense. Again, this is something that was already covered. Our committee has been ignoring its oversight duties in the face of open fraud and corruption taking place in this administration, and it chooses to flex its authority, again, over powerless people in the immigration community rather than over the places where real crime is taking place within the government. This bill is simply another effort to follow the narrative pushed by the administration, a fake focus on fraud that ignores the pervasive fraud taking place before us right away. The bill is unnecessary, it is redundant, and it does nothing at all to combat the actual fraud that we're suffering from in the country. I urge members to oppose the bill.